Assalamualaikum warahmatullahi wabarakatuh. My name is Intan Maisarafika binti Muhammad Razali. My matric number is S51119. So today I want to present my report about the question in law subject. I have answered the question number 1 and number 2. So the question number 1 is, Ali, the youngest of 3 siblings, has been offered to study at University Malaysia Terengganu. His 2 older sisters, Amina and Alia, promised to provide allowance for him 500 monthly, on the condition that their mother transfers some land to both of them. Their mother agreed and transferred the land to Amina and Alia. Both of them, however, failed to fulfill their promise, and Ali sued them for the promise, advised Amina and Alia. So for the issue of this case is whether Ali can bring an action against his sisters or has the right to sue his sisters for the amount promised in the contract where the consideration for such promise has been furnished by the mother of Amina and Alia. So the principle that we use in this case is the definition of proposal in section 2A of Contract Act is when one person signifies to another his willingness to abstain from doing anything with a view to obtaining the assent of that other to the act of abstinence. He is said to make a proposal. A proposal made by one party to another party with an intention to do that, other party would accept his proposal. The general rule of an agreement without consideration is void and defined in section 2D under the Contract Act 1950. When at the desire of the promisor, the promisee or any other person has done or abstained from doing, or does or abstains from doing, or promises to do or to abstain from doing something, such act or abstinence or promise is called consideration for the promise. Rules that relating to consideration must be in a 3 condition. The condition number 1 is consideration must be sufficient, and number 2 is consideration needs not be adequate, and the number 3 rules is consideration needs not move from the promisee. So in this case, we use the 3rd condition that consideration needs not move from the promisee. Consideration is an act or abstinence or promise by the promisee or any other person as required by the promisor in return for the promise. Literally, it means something that is given in return or something else. Consideration can move from the promisee or another person is under section 2D of Contract Act when applied in the case of ven kata shinaya versus ven veri kata rakmaya. So the case of ven kata shinaya versus veri kata rakmaya, in the facts that a sister agreed to pay an annuity of Rs 653 to her brothers who provided no consideration for the promise. But on the same day, their mother had given the sister her estate. Subsequently, the sister failed to fulfill her promise to pay the annuity to her brother, and her brother sued her on the promise. So what held in this case is the sisters were liable on the promise on the ground that there was a valid consideration for the promise, even though it did not move from the brothers. So, for the application that we use in this case is, for this case, the consideration is an act or abstinence or promise by Amina and Alia in this case, or any other person who is their mother as required by Ali in return for the promise, which is to give 500 ringgit monthly. When something is given in return for something else, it is clearly showing that there is consideration that makes the agreement valid. So, the 500 ringgit is the consideration for their mother to give Aminah and Alia some land, and that land are considerations for Aminah and Alia to give 500 ringgit to Ali. In this case, only the mother and Aminah and Alia who are provide the consideration, whereas Ali did not provide any consideration. As accordance to Section 2D of Contract Act 1950, the case of Venkata Chinaya versus Venkataramaya, consideration can move from the promise or any other person. Even though Ali did not provide anything, the agreement is still valid. So the conclusion from this case is Aminah and Alia hereby are advised to pay Ali 500 ringgit monthly. This is due to there is no doubt in the validity of the agreement made by the persons involved. Hence, Ali have the right to sue his sisters for breach of contract if they fail to give 500 monthly to Ali. That's all for the question number 1. So we move to the question number 2. Satok is a licensed hunter. He used to hunt for porcupines and ant bear and sold them to exotic food restaurants. He entered into a contract with delicacy restaurants for supplying of porcupines and ant bear on 31st August 2019. However, on 5th September 2019, Parliament of Norway State passed a new law which prohibits any hunting and selling of porcupines and ant bear. Satok was aware about the new law and wishes to discontinue the said contract. Advise him. So, the issue in this case is a contract may be discharged by frustration. According to Section 57, Contract Act 1950, frustration is any impossibility of performance after the contract has been made by an unforeseen event occur or something radically that changed the circumstance, the contemplation of the parties at that time, the contract is discharged. Means that after you entered into a contract, if something happened or some event occurs which it makes you impossible to perform the contract, then that is a frustration in contract. It is not you to choose to not perform, but something happened outside of your controls. Because of this event, it is impossible for you to proceed the contract. The events that occurs during this situation is based on the supervening illegality. Supervening illegality is a contract which may become illegal as established by a change in the law that happens before performance becomes fully legal. If it is illegal, later a contract may become frustrated. The example case is a case of Avery versus Borden. The fact in this case is Avery versus Borden in 1856, which is an agreement to supply a cargo for a ship at a port in Russia. A charter party received a ship to continue to Odessa, and the charter's agent took a cargo there. The ship arrived at Odessa, and the master requested a cargo, but the agent was unable to supply it. The master of the ship continued to ask for wine. Suddenly, with the outbreak of the Crimean War, the government made it illegal to load cargo in an enemy port, so the ship couldn't perform its contract without breaking the law. The chartered sued. So what is held in this case is the court held if the actions of the agent lead to an anticipatory repudiation of the contract, the master had decided to hold the contract alive before it was discharged by frustration on the outbreak of the war. Moreover, if we look at the current situation, our government has given orders to control the movement in Malaysia, which is we call it as MCO, due to COVID-19. All the businesses, except the necessary businesses, need to shut down their businesses. Thus, the company cannot deliver goods and operates as usual, so whatever the contract that have been performed during period are frustrated. The contract will end automatically, and the parties do not need to proceed the contract. Based on the case and the situation above, it is impossible to perform the contract because of some reasons. For the application that we use in this case, Satok entered into a contract with Delhi Cozy Restaurants for supplying for porcupines and ant bear on 31st August, so there is a contract between them. However, on 5th September 2019, Parliament of Norway State passed a new law which prohibits any hunting and selling of porcupines and ant bear. Something radically happened that changed the circumstances during the Satok entered the contract. The contract was discharged. So, does the wishes that Satok want to discontinue the contract can be proceed or not? The answer is yes. According to Section 57, through all the principles and case given above, Satok's situation was under the supervening illegality. He can discontinue the contract as the contract is frustrated due to the changes of the law. So the conclusion of this case is, it is clearly stated that the discharge by frustration under considered by an event can end the contract automatically because of unforeseen events that occur. They did not have to perform the contract anymore. Hence, the objective of frustration is to achieve a fair and rational results between the parties by realizing that events occur that can make it is impossible to perform the contract. So that's all from me. Thank you.